Welcome back to the Legal Alternatives Podcast. Me, SamPawson, joined us every by Nils. Nils, how are you?
I'm good, Sam. You enjoying the sun?
We are, yes. Explains a more casual attire, I think, today. As we record, it is the hottest week of the year, so touching 30 degrees, only to get hotter in our unconditioned office in Leeds. But no, lovely to have the sun out on a busy week, as always. I think you're kicking us off first, Nils, this week.
Yeah, just a very quick update from me, because we've got a really important and interesting case to discuss on your side of things, Sam. The trend that we've been discussing on this pod for quite a while, in fact, probably since we've been doing the pod, is that it's getting harder to employ migrant workers. So perhaps some welcome news, particularly for certain sectors of the economy, that the government has announced a new concierge service and visa scheme to help what's called scale-up companies. A new announcement has been put together by the government. Measures aim to help high growth business start, scale and remain in the UK and attract global talent. So there's going to be a visa reimbursement scheme for eligible UK scale up enterprises in digital and technology, life sciences and clean energy. And it's certainly, if you are within that part of the UK VI arena, or those parts of the economy, it is worth doing, because you can actually claim up to £5,000 per eligible international hire and their dependents, with a total funding of up to £25,000 per year. So quite a big reimbursement on visa fees there. To be eligible, an applicant must be applying under one of the designated immigration routes, so skilled worker, global talent, scale-up worker, and the usual criteria apply. So you've got to have a sponsor license, all the requisite eligibility requirements. Applications for reimbursements are accepted from the 16th of June through what's called a grants hub portal, although any fees incurred after the 9th of June, you can actually reclaim. And also what's called an Office for Investment Fast Track Referral Route for UK expansion worker sponsor license applications being set up. To assist what's called high potential overseas businesses who want to establish a UK presence more quickly. So designed to speed that up. We think it's available now, although that's not particularly clear. And if accepted for a referral to that office, we talked about the concierge. That concierge removes quite a bit of time, 10 working days instead of potentially up to 8 weeks. So two positive pieces of news in the world of immigration.
I think, while obviously we are never claimed to be a political podcast, I think it would go without saying, obviously, time of recording, we are expecting obviously a change in Prime Minister. What I think this is obviously unlinked to that, but what it might be seeing again, and whenever we've got a change in Prime Minister, is again maybe a change of direction in a lot of immigration. Part of obviously Keir Starmer's start of his premiership was appearing obviously very strong on immigration control. That might continue, but again, we can also potentially see the softening, and it's interesting just in terms of timing. Some of the softening came right at that kind of end of the premiership. So I'm sure, like all areas of kind of legal world, some change might come in the future.
Yeah, and we'll keep people up to date on what, if any, of those changes are.
Yeah, absolutely. My update today is kind of well timed in a way, because it's actually a case that's been reported this week that supports and I think gives a really good factual circumstance to something we've talked quite a lot about, which is sexual harassment, both in terms of the protections that are coming in October, but the lots of changes we've had around sexual harassment. And really, one of the key questions that a lot of our clients have is the idea of, if harassment occurs outside of our employers liable for that? So are we liable as an employer for the actions of our employees if they happen outside of work? And we've talked about that and in some detail in podcasts, but this case of AB and Grafters Group came out this week, which is actually a Court of Appeal case. And I thought it was really useful to kind of share and I'll go into some detail about the factual background. So it's important, but as I've suggested, it's a Court of Appeal decision, which always carry more weight. And the Court of Appeal have given some really good guidance on when is something in work and when is it, if it's out of work, where is it still connected to work. So I'll go through a bit of the factual background, Nils, and then I'll get your opinion as well, because it's something that is really important for employers to understand. There may be a view for employers that it's again putting quite a high threshold on them as employers when they're dealing with, and you'll see in the facts of this case, unfortunately, some quite horrific behaviour from employees. Sorry. So claimant in this case, AB, they've been anonymised obviously for the case, worked in the hospitality section for this. For the respondent. In 1st of November 21, they believe that they were attending Hereford Racecourse as part of a work event in marketing, so not in the usual kind of event that they would attend. However, when they attended the respondent's office, they got into the car of a colleague who they thought they were attending the event with. The colleague, known as CD, offered a lift to that event, and which she accepted. Employee then got in the car, and it transformed actually that this wasn't a work event and that she wasn't due to work that day. At that point where she found that it wasn't a work event, she's asked to be taken home. The other employee has not done that, and unfortunately has then sexually assaulted the employee. So awful circumstances. The matter has been reported to police. The employee has then resigned, criminal proceedings brought against. However, claim then brought against the company on the basis that they are vicariously liable for the harassment committed by their employee. That case was then held initially by the Employment Tribunal, which came to the decision that the employer wasn't vicariously liable for the actions, however horrific, because it didn't take place in the course of her employment. So what the tribunal held was the incident took place outside of normal working hours, even if the employee themselves believes it was a work event. The employee wasn't scheduled to work on that day. The lift wasn't organised by the company, and the company didn't have any awareness of the lift. And the tribunal concluded that the motivation of the individual, the perpetrator, was his own and not linked to his job or carrying out those awful acts. So the claim in the tribunal and the ET was dismissed. The claimant has then appealed that decision, and I believe probably unsurprisingly, the EAT has overturned that decision. The decision was appealed on 3 grounds. That essentially, which the tribunal agreed with all of them. That the ET initially overlooked relevant factors, including historic messages had been sent between the 2 individuals that had, in the view of the tribunal, been harassing in nature. So there was a chain of causation. It focused on irrelevant considerations such as the individual's motive and the lack of approval, and it failed to ask whether the incident was sufficiently connected to work, so an extension of that employment. So the tribunal, as I say, confirmed that and found that the tribunal misapplied the law. And the tribunal produced some quite helpful judgments in terms of what should have happened and what the kind of tests for our listeners should be. The EAT in a situation stressed that informal situations such as car journeys, work-related events to social activities can fall within the course of employment where there is a close link to work. So what we're looking at is the link to work rather than whether we are arbitrarily in work time or if the individual thought they were working. So it's the link that the key. They stress that obviously these are very fact-dependent cases, which will turn on the fact, and critically that the tribunal failed to look at this chain of events, that this wasn't a one-off incident, this was incidents that were connected, and those messages took place in kind of work time. Again, they also examined whether the exception of the lift influenced whether it was work related, found that it didn't, and ultimately held that there was a degree of control and that really linked to the course of employment. So that decision really was clear that what employers need to look at is that connection to work. As I say, personally, don't think the EAT's decision is too too surprising. I think the original tribunal decision was. This to me is linked to lots of cases that we've talked about social events connected to work, gatherings for drinks, your after parties for Christmas events, where the reason the individuals are together is the connection to work. So for me, in this case, one, that there was obviously a false narrative that connected to work in terms of the claimant believing that they were working. But then that the only connection to these individuals was their work. I think there is a clear connection, and can understand why there therefore has been a decision that the company is vicariously liable. Views, Nils.
Did that go from the AT to the Court of Appeal after that?
So I think I did say it's a Court of Appeal case. It's an EAT decision, not a Court of Appeal decision. My apologies on that. So it's a case that's being appealed. It will now go back to the tribunal in terms of for findings and in terms of settlement. But yeah, important decision to be overturned. So I don't know views that you have on that kind of.
Well, first of all, absolutely horrific set of circumstances and thoughts with a person who's been the subject of that awful behaviour. I think my thought is it's a bit like a health and safety case. Once you've got that connection, the question then is, have you done everything possible? And those for me are the two key points. Have you done everything possible? If there's a connection with work, the only reason those two people together is because of work. Yeah. So it doesn't surprise me, the EAT judgment. Yeah. And you can, in some of these instances, however horrific the treatment is, employers may come and say to me that, Sam, what can we do? This is just someone who has committed a heinous crime that we can't control. We can't control, if someone is ultimately, evil or not. It's someone who's committed an act that no one could have foreseen, and you'd have some sympathy for that. But they are, as I say, very fact-specific cases. But wanted to kind of highlight it as when I'm saying about extension to work, it's not just a soundbite. It's real cases and real, where individuals are held to be vicariously liable. And I think as heinous as that is, there's always something, what about a policy saying if you meet up with somebody in work that you work with, that is outside the scope of work. Yeah. We don't encourage that, and we don't want people to, that might be one answer to that. I think so. And then in terms of it's a really good question, is what can employers do? And I think, that absolutely is fundamental. The policies, how you're training staff. Yeah. Obviously, ideally you want to prevent any of this action from occurring in the first place. So, that prevention, as we've talked about before, this will get harder because in October employers have to take all reasonable steps. So again, I think this case was judged on the old rules. I think on the new rules, even more likely that it would have been kind of held vicariously liable at the first instance. So, lots to take away with in terms of a case. Good illustration of kind of what we've been talking about over the last few weeks. Yeah, and interesting but sad. Yeah, absolutely. In terms of things coming up out the office, Nils, I think our last update, we've both had a run, haven't we? Yeah. Since and did the Leeds 10K, which was a good day out. I think we mentioned our seminar program has now come to an end, but lots to come. As I mentioned, I think the political landscape, only more issues and more questions are going to come out of it. So I think busy time as always for us. I think it is going to be. So yeah, looking forward to the next few months and keeping everybody up to date with what's going on down at Westminster. And that's all for us this week. I'd just like to mention on the podcast, if there's ever a topic you'd like us to explore, we really like to kind of know what the listeners want us to talk about. So any topics, any suggestions, leave us a comment in the comment section. We'd love to hear from you. Don't forget, subscribe to the updates, both the MMD and the weekly podcast. Give us a like, always helps on YouTube to send us a like, subscribe to the content, more insights again on the website, subscribe to the Monday Morning Dispatch, and we'll be back next week with another podcast. So it's goodbye to me. Goodbye. Thank you.